sometimes bordered on failure to assist a person in danger of being killed. The United States.
Thank you, Madam President. Madam President, International Educational Development Humanitarian Law Project, one of the few non-governmental organizations specializing in humanitarian law, has welcomed the work of Subcommission member Mrs. Claire Pally, both her initial paper and her paper now before the Subcommission. We were severely disappointed by the action taken at the Commission on Human Rights on this issue, and were all the more disappointed because the government of the United States, a key participant in the humanitarian activities debates, and a key player in provision of either real or so-called humanitarian assistance, led the charge against this study. We feel that the United States position is a misguided attempt to stifle serious work and debate on this and the other vital issues presented to the Commission by the Subcommission. We are saddened that other governments went along. The United States action was doubly unfortunate because rarely has the Subcommission had the requisite expertise that it has uniquely with Mrs. Pally to undertake a study of this nature. We strongly urge the Subcommission to insist to the Commission that this study be undertaken. Assuming that the Subcommission will do so, we wish to point out some concerns to the rapporteur. In some situations in the past, the United Nations became involved, but then faded away before there was a permanent solution to a crisis. It is important that the rapporteur evaluate the reasons behind the failures of these efforts, especially because, in some cases, the problems continue and, in fact, worsen. For example, as part of the transfer of sovereignty from the Netherlands to what became Indonesia, the United Nations established a United Nations Commission for Indonesia, which became a party to the Round Table Conference agreements found at 63 United Nations Treaty Series at page 3. The agreements provided that the new country of Indonesia was to be a federal structure in order to recognize the rights of self-determination of the individual peoples and states, such as Maluku and Aceh, within the territory. Maluku and Aceh were to be allowed to negotiate a separate status if these areas did not ratify the Indonesian constitution. Very shortly after the conclusions of these agreements with the United Nations, Indonesia used armed force against Maluku and other areas to try to create a unitary state. The Moloccan people declared the Republic of South Moluccas on April 25, 1950. The United Nations Commission on Indonesia was asked to intervene, but Indonesia refused action under the pretext that the United Nations action would encourage the rebels. The United Nations Commission on Indonesia became inactive in 1954. Yet the international community is still left with the need to resolve the Maluku and Aceh situations. Such a hiatus. Humanitarian law applies whether or not a state recognizes it. Humanitarian law applies when objectively there is an armed conflict. In no recent internal armed conflict has any state actually recognized humanitarian law unless forced to do so by the international community. States prefer to refer to terrorism as if invoking terrorism allows them to ignore humanitarian law. It is time to put an end to this misuse of humanitarian law and remind all countries that where there is internal armed conflict, humanitarian rules automatically apply. To reinforce this point and to provide an answer to the question of whether or not United Nations forces are obligated under the Geneva Conventions, IED wishes to draw to the attention of the subcommission and the rapporteur the case Nicaragua versus United States, 1986, International Court of Justice, beginning at paragraph 315 and following, in which the International Court of Justice states categorically that Common Article 3 to the Geneva Conventions is the quote, minimum yardstick, unquote, of all forces, all peoples, at all times, regardless of whether a country has ratified any particular instruments of humanitarian law or in fact are even actually involved in a conflict. The United Nations system is currently lacking both coherence and vision. Mrs. Palley's study is badly needed as part of a process to bring understanding and uniformity as well as full integration of human rights and humanitarian standards into all operations of the United Nations. Thank you, Madam President.
Thank you for your statement, and I call on Four Directions Council. Four Directions Council. Are you here? Right. I call on human rights advocates.
Thank you, Madam Chairman. At this afternoon session, serious discussion by NGOs of Mrs. Palley's remarkable report must necessarily be brief and merely illustrative. Human rights advocates seeks to focus on the statement in her paragraph 34 that was discussed this morning that the question is whether the Security Council must always have regard to the basic principles of international humanitarian law and to human rights law. That is to say, humanitarian law and human rights law are essentially complementary. And we think the answer to the question is yes, that is true. We believe that the affirmative answer applies to all United Nations bodies and their personnel, including those engaged primarily in humanitarian